Retirement can be a good time to focus on legal matters and ensure your legacy is taken care of. A big part of that will be making certain that you have written and legally checked a will. It's a subject that some people can feel uncomfortable talking or even thinking about, but it is hugely important. And ultimately, your family and friends will benefit from your forward thinking. Alan has been speaking with the Will Writing Company.
Am I planning for retirement? Yes. I'm now of that age that I'm now thinking about, within the next 10, 15 years I will be retiring. And it's really important now that I start to think about my plans for that.
The issues that you need to consider when making an end-of-life plan are quite emotional for a lot of people, and we understand that we need to deal with those issues very sensitively. Sometimes it's about ensuring that a will is put in place to make sure that the right things pass to the right people, but it also might be appropriate to consider a trust or a lasting power of attorney, again to protect your loved ones and your family.
A will is a formal legal document that sets out what your wishes are and who should benefit from your estate after your death. If you don't set out your own wishes, then various other rules are imposed on you. Your estate may not go where you want, and you certainly won't have thought of the various other issues you might have needed to think about.
If there's no surviving spouse or civil partner, then we'll look at if there's any children. If there's any children, the estate will pass equally to them. If there's no children, then it will pass to parents. If there are no surviving parents, then it will go to siblings or to their children, and then to any surviving grandparents, and then to aunts or uncles, and then cousins. And finally, if there's no one to take from the estate, no surviving relatives, then it will pass what's called bona vacantia to the Crown.
I meet people and talk to them about their situation and determine whether they are interested or there is a benefit for them in making a will. We also talk about lasting powers of attorney and family trusts.
My will is something that dictates what's going to happen if I die. If I die, I'd like my assets to go to the relevant family and friends, rather than simply just go the way that the law wants it to go. I had a cousin that died a few years ago, and it took 5 years to administer their estate. They had no will, and this involved a lot of solicitors' costs and a genealogy company spending, I think it was a number of years, working out who the relatives were, contacting people. So off the back of that, it's really, really important to have a will in place, because it can then become so simple.
If you're doing a do-it-yourself will, it may not be set out in the right form, it may not have covered all the issues, and it may not meet all the formal requirements under the law to be a valid will. We get clients coming to us all the time with other wills that people have done, they've done themselves, where it hasn't worked. It's expensive to sort out, it's very emotionally draining, and it can cause huge problems within families.
It's very important that when you get the legal paperwork in place that you store that paperwork in a very safe and secure place so that it can be accessed by the family at the time of need. It's very important that you communicate to the family and your loved ones that you've made those important steps, again just to ensure that the access can be attained at the right time.
Over the last 3 years, we've invested substantially in web-based technology to enable our customers to connect with us 24 hours a day. Every customer is provided with a unique login, and they can view and review their own documents online, and they can communicate with us online from wherever they are on an internet-enabled device, be that a mobile phone, an iPad or a desktop PC.
The process of getting a will, it was quite straightforward. I did actually have a simple will that I did about 20 years ago, and I've not done anything with it. I haven't updated it, but my circumstances have changed. My wider family circumstances have changed a lot with marriages, births, deaths, and my building society suggested that I should see a consultant about wills. I knew that it was something I should do something about. And so I said yes, and I met the consultant at the branch, and it's a very simple, straightforward process.
Although you don't need to use a solicitor to draft or to witness a will, it's always a good idea to have a legal professional looking over it, make sure you've covered all the issues. And the most important thing, we think, we always attend the meeting when the will's signed, because that's when the most mistakes are made, and those are the things that invalidate the will.
It's down to the individual as to how much information they discuss with their family whilst they're alive, but certainly communicating with them will make things easier when the time comes for them to act on those plans in place.
Our recommendation is that the useful life of a will is about 3 to 5 years. Any change in your circumstances or those of your family should cause you to think about it. And the things that you might want to think about are those things you read in the back pages of your local newspaper. If there have been any births or marriages or deaths or divorces or bankruptcies of any of the people named in the will, you should sit down again and just reconsider it.
I put a will in place because I was aware of wills and trusts. I was doing a lot of travelling, and I was just aware that it was something that I should do. It was a very simple one. It simply, left my assets to my parents, and if they weren't around, then to my brothers. But I now have more assets. The family is now completely different. So it really isn't fit for purpose. So therefore it was really important that I took out a new will and looked at the broader planning.
In our sector, the industry is unregulated, and many practitioners aren't part of any regulated entity. We are covered by an Institute of Professional Will Writers Code of Practice, which has been endorsed by Trading Standards. And that code of practice requires us to have professional indemnity insurance to protect our customers if anything were to go wrong, and also requires us to protect client money.
It's definitely given me peace of mind. And what was interesting was when I saw the consultant, he highlighted a number of things that I just hadn't considered. In respect of young relatives. I have some young nieces. What happens if they grow up, they get married, they then get divorced, and assets move around the place. So there are a whole load of things that I just hadn't considered, that the consultant highlighted to me, and clearly he sees this all the time, and he's saying, well, this is what often happens in this situation, and we all know that families and money can be very complicated, and so it's really important for peace of mind to lay out what I would like to happen. And now I can rest easy knowing that that's all done, and then every now and then I just review it, and I can then get on with other things.
When the time comes to what's called prove the will and to execute it and make sure it has the effect, then it's very important that you're dealing with the last will and testament of the person. We always have to make inquiries. We make sure there are no other wills. We get the relatives to search among the papers. If it's been a client of ours for many years and we've got various versions of the will, then we always check that it's the most recent one that they're using, or that the personal representatives are putting forward to execute. And the very important things, we always check all of our wills when they come back to us have been signed properly and are valid. But other wills that we see that come to us for probate or for administering the estate have been signed in the wrong place. We've had ones where a relative of one of the beneficiaries has signed as a witness, which means that person can't benefit. They haven't been dated properly, and there have been alterations that haven't been done properly.
Historically, solicitors would normally be involved, and I just find solicitors really frustrating to deal with. And the opportunity of seeing specialists, it's rather like moving house. There's now people that specialise in conveyancing, and I'm very happy using a straightforward conveyancer because that's what they do day in, day out. And this seems to be the same with a specialist will consultant. That's what they do, and therefore there's no distraction. They know what they're talking about, and they deal with the same clients day in, day out, or same circumstances.
The witnesses to a will have to be old enough to know what they're doing, preferably over the age of 18. They have to realise that it is a will that they're witnessing. You have to have two witnesses who are both present at the same time and in the presence of the person signing the will, whose will it is. The witnesses shouldn't be beneficiaries of the will, otherwise they won't take the gift, and they shouldn't be married to or closely related to any of the beneficiaries in the will.
The Crystal Mark scheme is an award granted by the Plain English campaign. It's an award given to organisations who've written their legal documentation or contracts, terms and conditions, in a way that make them utterly comprehensible for the consumer. Too often legal documents are in jargon that people don't understand, and the Plain English Award is awarded to organisations that express themselves very clearly.
Join us after the break to find out more.
If you need to make or review your will, contact the Will Writing Company, part of the Estate Planning Group and one of the UK's largest estate planning experts. For complete peace of mind, our viewers are being offered a free, no-obligation consultation at home with a money-back satisfaction guarantee. The first 1,000 viewers to register will also qualify for a 15% discount. It's an offer that is too good to miss. See website for details.
Are you concerned about memory loss? Many people are. It's understandable. Scientists now link memory loss associated with Alzheimer's and dementia to a rise in the level of the amino acid homocysteine in our blood. Homocysteine can be reduced by the ingredients in Betronac, a simple one-a-day supplement containing the highest doses of B vitamins, folic acid, and the powerful antioxidant NAC. Memory loss? Try Betronac, a research-based solution.
The Society of Genealogists can help you with your research. The largest family history library and archive in the UK contains some remarkable collections. Why not become a member to gain remote access to the Society's growing online database of records? The Society also runs an extensive education programme of family history courses and publications which may be relevant to your ancestry. Contact us now.
The holidays are over. Time to get healthy.
But I don't have time.
Curves provides 30-minute workouts. And didn't you say you were going to change your eating habits?
Yes, but I don't know how to.
Curves has customizable meal plans. Come on, let's do it.
But I'll never follow through.
I'll be your personal coach. Designed specifically for women, Curves is as easy as 1, 2, 3. 30-minute workouts, customizable meal plans, and personal coaching. Visit your local Curves now for a chance to win a trip to the Caribbean.
If you need to make or review your will, contact the Will Writing Company, part of the Estate Planning Group and one of the UK's largest estate planning experts. For complete peace of mind, our viewers are being offered a free, no-obligation consultation at home with a money-back satisfaction guarantee. The first 1,000 viewers to register will also qualify for a 15% discount. It's an offer that is too good to miss. See website for details.
Welcome back. We've been talking with the experts at the Will Writing Company about the legal considerations we all have to make. Safe storage of legal paperwork is essential. Keep a record of everything you have and where you've stored it, and discuss with your legal advisors appropriate procedures for when you need to update or access the documents. This will avoid any unnecessary worry when the paperwork is required.
A lasting power of attorney is a legal document which enables you to appoint a trusted person to deal with your property, your welfare or your money. It's important to have a power of attorney because it allows you, while you are well and have capacity, to make a decision as to who would be able to deal with your affairs if you either decided you didn't want to anymore or you couldn't because you'd lost your mental capacity.
There are two types of power of attorney. There's a health and welfare and property and affairs. Effectively, when you give someone the power to be your attorney, it's like stepping into your shoes. They become you and they make the decisions that you've given them the power to do. With the property and affairs, that means that you can make decisions about selling the property and also about the financial aspects of your money, looking after your bank accounts for you, and if you want to buy a birthday present for someone. With the health and welfare, that will help that person Make the decisions with your guidance about the type of care that you may need in later on in life.
People you should consider appointing in your lasting power of attorney are people that you trust, absolutely, because it is a position of power and authority. So it can be your spouse or your civil partner, it could be your children, or it could be good friends, but always people or a person that you trust absolutely, who will always act in your best interests. Lacking mental capacity means you can't make decisions for yourself anymore. That might be as a result of an injury or a condition or an illness. It doesn't always have to be permanent, it could be temporary.
A power of attorney can last for as long as you want it to last. You can make it a temporary agreement, for example if you're recovering from an accident, or it's a permanent tool that you use until the end of your life. It's entirely up to you, it's your decision and you set the terms.
We have a very rigorous compliance process, so whenever a client's instruction is presented to us for processing, we have a highly qualified legal team that analyse those instructions to make sure they comply with best advice and all current legal requirements.
Assessing mental capacity varies from case to case, and we are used to dealing with elderly clients or clients who have been unwell. So the way in which we assess their capacity will be different depending on their circumstances. In order to have capacity to make a lasting power of attorney, a person must be able to understand the nature of the document that they're signing. They must be able to make a decision. Can they make a reasoned decision in their circumstances? Can they retain information, and can they communicate to us their decision? That can be in a variety of different ways. They could write their answer, for instance, if they have difficulty speaking, or sign language. It's whatever is appropriate in that circumstance.
The Bill Writing Company can make this a very simple process for you. We can start with drafting the power of attorney for you and guide you all the way through to the end of the process where you will register that power of attorney for when you actually need to use it.
I think it's all about getting the right advice and making sure that you talk to people who have got your best interests at heart, because knowledge is the key. I recently spoke to my mother and stepfather about their personal circumstances and what measures they wanted to put in place, and I did spend some considerable time talking them through all of the options. They have an advantage. They have a daughter who can obviously assure them that I have their best interest at heart. An awful lot of people don't know where to turn to. There are lots of different options out there, so it's important that you speak to somebody who has knowledge in this area and who will give you the best advice for your situation, so they don't have a personal interest. But it's very important to speak to somebody who has the appropriate knowledge.
An estate planning consultant is a field-based consultant who advises our clients for the Bill Writing Company. Each consultant, when they join us, they go through a rigorous training programme. They're all qualified by the Institute of Professional Will Writers, where they sit an exam. They have continuous professional development on a yearly basis, and they're monitored by myself and also by our legal team to ensure that they give accurate and correct advice to our clients.
Now and again we'll meet clients that for whatever reason can't agree towards a common estate planning strategy. What we do in those circumstances is remind people that there is a consequence of inaction. The consequence will result in them dying without wills. Their estate, their belongings and what they own will be passed according to very strict rules called the rules of intestacy. It's very likely that the rules of intestacy will do a worse thing than perhaps the next decision that they would have taken.
The legal rules, although they may seem reasonable, can prolong the administration of the estate upon a person's death, and they can also cause further distress to the surviving relatives. And also it could reduce the estate of the deceased through the costs of having to go through the intestacy procedure. It could also, cause potential arguments between family members.
I think there are two mistakes really. One is not making a will and assuming that everything is going to be all right on the night, because often it isn't, and not having a will can lead to disastrous consequences. The other common mistake is trying to go it alone. trying to achieve an outcome by DIY kit or just simply writing it on your own, not understanding the legal complexities and making a fundamental mistake which can actually cost far more to unravel than the cost of the will in the first place.
The common mistakes that we see when wills come to us to be proved or to be looked at are they haven't been signed in the right place or by the right people, that they failed to take account of all of the assets and all of the property, so some of it passes under different rules, not in the way that the client would have wanted. We see references to common law wives, and unfortunately there's no such thing as a common law wife. People tend not to realise that a divorce can change the provisions of a will, and with second marriages being so prevalent nowadays, that when you marry, it revokes all previous wills. Something that a lot of the general public wouldn't realise is that family independents can make a claim under, let's just call it the 1975 Act, if they feel that reasonable financial provision hasn't been made for them in a will. So in this country, you can make a will, you can leave what you want to who you want. But if certain members of your family or certain people you've been supporting financially are disappointed at that, they can make a claim against it. That doesn't mean it would succeed, but again, a lot of people wouldn't know that, and unless they'd discussed with an estate planner the potential claims, it could come as a very nasty shock to the other beneficiaries.
I remember seeing clients several years ago where the husband wanted to include one of their children to benefit when he and his wife passed away, but the wife, for whatever reason, didn't want to include him in the will. Now, if they'd have left that situation as it was, and they'd have died without wills, the rules of intestacy would have benefited that son. So one of the husband and wife would have found that their wishes weren't carried through anyway. We managed to discuss the issue and reach a resolution whereby the son was to be included but would receive a lesser share than his siblings. We found at the end of that discussion that both parties were happy.
My experience of customers reaching retirement is that they want to focus on the happy things and things that they've always planned to do during retirement. And one of the ways to achieve that is to take care of some of the legal paperwork and processes that you have to go through, get that done, get that behind you, and focus on enjoying your life. And we find that that's a real catalytic moment for most of our clients.
It is important to have adequate life insurance. Although we're not financial advisors and we're not able to give advice in this area, it's very important that we can point people in the right direction for that advice. Again, it's to ensure that the family are protected financially for their future.
I have vague plans of sailing, kayaking, travelling, maybe even doing some professional yachting. Hence why I'd like to get to the position that I have sufficient plans in place that I can then sort of live day to day almost. I know that as I get older, I'll be less, ultimately I'll be less active. So what I'd like to do is go through this period where work is no longer the priority. Experiencing things, enjoying myself is the priority. Acknowledging that at some point I'll then slow down the pace and my requirements will be very modest and I can have a nice, happy, comfortable retirement.
I'm very aware that as we live longer, our brains can give out before our bodies do. And I really wanted to have made certain decisions beforehand and communicated them in a legally binding way. So that my wishes would be carried out, and most importantly, that those sort of decisions at a very difficult time wouldn't fall on my wife or my children.
My thoughts on retirement are we plan for every eventuality in our life, and something that we don't tend to plan for is the end of our life. By putting plans in place, it's giving your loved ones and your family peace of mind.
Retirement for me means having the freedom to do the things that I want to do, but also to have the financial security so that my money lasts longer than my life, and that at the end of the day, money, wealth, assets can pass down to loved ones and family intact.
The promise of retirement should be exciting and exhilarating. An opportunity to plan holidays, start new hobbies, and learn different skills. It's also a time to take stock of what and who we value most. To know that, even after we're gone, we'll have done all we can to look after the people we love.